In a civil litigation lawsuit, as opposed to criminal, when a plaintiff brings a claim for personal injuries or the wrongful death of a loved one, the court is going to issue, one of the questions the clients ask is, well, what's going to happen when, and where's it going to settle, or potentially settle, or not settle, and do we go to trial? The court's going to issue what's called a scheduling order. And every single court issues a scheduling order. It's going to set the period of time when discovery has to take place. Discovery is when we force the other side to give information that's theoretically helpful to pursuing the plaintiff's claim, our client's claim. The other side's going to ask discovery from us, which theoretically may entitle them to try to argue that, well, maybe they weren't at fault after all. Both sides get an equal shot, an equal chance at that. One of the other things the judge is going to do is he's going to set a period of time within all depositions have to take place. Another thing the judge's scheduling order is going to do is he's going to say, by a certain period of time, the parties must mediate. What is a mediation? It's not in front of the judge. It may be in front of a retired judge not hearing your case, but it will be in front of someone who is a third party who can oversee. It's very informal. Everything said at a mediation is confidential and private. Nothing said at a mediation can be repeated back at a trial. And the reason for that, it's intended that each side put their cards on the table. The plaintiff will theoretically say why there's liability and why the damages are and what that amount of money should be in just compensation for a client. That's what our firm does routinely. The defendant will say, well, here's why, here are certain facts why there's no liability. Here's certain facts why she ought to be able to, or he ought to be able to go back to work, and maybe the damages aren't quite what the plaintiff is making them out to be. That happens in every single mediation. First of all, a mediation shouldn't be intimidating for a client at all because the only people talking are the attorneys. I've sat next to clients, they see what I have to say on their behalf, and I tell them all the time, whatever the other side says, don't react to it. Whatever they say. Now, one of two things can happen at a mediation. The case settles or an impasse is declared. Impasse meaning there was no agreement to resolve the case. Can the case settle a week later? Yes. Can the case settle walking up the courthouse steps 6 months later? Yes. And that's a decision for the client to make with the advice of the law firm. Okay. Will a case perhaps maybe not settle? It impassed at mediation and it might go to trial. It does go to trial. That's a decision for the client to make. That'll be in their prerogative, if you will, based upon the advice of our firm.